Hello everyone. Good day and welcome to WIF Academy. We understand the exams can be a super stressful time of the year, especially now with so much of it being online. And we have curated this event so that we can help as much as possible. What has been your experience with online exams and what advice do you have for us facing it for the first time?
Sure. So I think that everyone can appreciate that online exams are obviously very different from in-person exams. And, I'm assuming that the first and the second years, you'll have no experience with it whatsoever. So I think the exam as such, like the questions that we're posed with aren't really different. They're the same. But just the preparation and the approach that you take towards it and the way it's marked is what's different. So you don't have to worry about what's at the questions end of it, or is it going to be a different paper pattern or something. Like Vartik said, it's pretty easy. It's either a problem question or an essay question. So you know exactly which side you have to prepare into. The advice and my personal experience that I would like to share would be that I think online exams, they expect you to go more into depth rather than into width. It's not about knowing all the law, but it's knowing enough about the nuances of the law to be able to talk about it and actually critically analyze everything. Another point on the references that I thought was a blessing in disguise was that even though we have online exams and we have the 24 hours, the law school does not expect you to, reference in proper or scholar type referencing. So, but it is obviously, I mean, if you are given the 24 hours, then it does make sense for you to at least take the effort of, putting your case in italics and putting putting the case here in front of it. That's one. And you are expected and you are encouraged and you are rewarded if you kind of cite academic authors and take their name, or probably cite the journal that you got it from. But again, that's not entirely necessary. What I would say is just citing the author is enough. You don't need to go to the extent of citing the journal. But that would be the one advice or one experience that I would give. Another thing that I learned, or my approach to the preparation towards the exam, was to organize your notes, because you don't have to learn anything anymore. Like it's not rote learning. It's not how many cases you know. It's how many cases you remember. It's how many cases you can apply to the given scenario correctly. So I would say that you should organize your notes effectively in one place so that it's easy for you to refer in a 24-hour window. What I would usually do is, say a week before the exam, I'd have my notes all organized and I'd go through them. So I'd familiarize myself with like how the notes are placed, like what comes before what. So it's easy for me once I see the question to be able to, automatically think that, hey, okay, hey, this is, I know exactly what I have to deal with under this topic. And specifically when it comes to law, I think Vartik will agree with me on this. The way the topics are set out when the in the course structure itself, that it's broken down into 8 to 10 issues. So if you can kind of make notes on those 8 to 10 issues, and something that I personally found really, really valuable was discussing it with a peer. So I basically became best friends with someone on my course just because I studied with her last year. And I thought that it gives you a really great perspective, but at the same time, it also challenges you to think, and it challenges you to put your arguments forth in a better way if you prepare with someone. So that is the advice that I would personally give: is organize your notes, discuss it with your peers. And lastly, I think the ops team has put this up in the resource pack, but there was this app that I really used. It was called Quizlet, which was basically flashcards with all the cases for each module. So I think, like, just for light revision, probably before you go to bed or when you wake up in the morning or when you're on the move or whatever, I think that was really helpful for me as well.
Thank you so much for that. Vartik, anything else you would like to add?
Yeah, just a few points. I think obviously Anushka and I, being from the same batch, we have more or less the same experience with online exams. And of course, last year was the first time ever that online exams were held. So it was quite a last minute change for us as well in that regard, especially being in our second year and it actually counting towards our final year marks. But yeah, I mean, it wasn't really a paradigm shift in terms of the way we prepared for our exams. I feel like that was more or less the same. It was just the expectations, I would say, of the examiners, because for instance, when it came to our first year exams and we had to give those in person, there was a certain weightage attached to your knowledge, not just application and critical analysis, but you basically remembering the cases, the statutes, and how to go about it. But I think in online exams, since they're essentially open book and you have access to the materials, having that knowledge is sort of granted. I don't think they expect you to have that. So I think they'll pay a lot more attention to your application and your critical analysis than they will to your knowledge. And in any regard, whether it's an in-person exam or an online exam, I feel like knowledge is a given. It's the first step really on the marking ladder. At least that's what we have been told since we've come to Warwick. And yeah, I think the great part of this as well is that we have a choice of problem questions and essay questions. So I think in some modules, Anushka can probably clarify this. In some modules, I feel like there's a minimum requirement of doing one of each type. So you have to do at least one problem and one essay question. But I think in certain modules, if I'm not wrong, I think trusts is one which we have this year. We have a free pass to do either 3 problem questions or 3 essay questions. So it's quite a flexible environment, I would say, these examinations. It's almost as if, Warwick Law School is giving you a hand and being like, we want you to do well. So all you have to do is grab it with your hand and make it work.
Thank you so much for that. So the next little slide that we have for you guys contains some of the resources and tips that our panelists use themselves. So these are some of the things they found most useful when preparing for online exams. They will also be updated in the chat box below. So please make sure that you look out for the same. So some of the resources that they gave us when we were preparing this slide was Warwick Library. It's a great resource. CaseMind, Law Express, Law Teacher, Law Trove, LexisNexis, and Quizlet, as Anushka mentioned earlier. So all of these resources have their links attached, and you guys will be able to access them through the chat box. So please make sure you look at that. So now we'll be moving on to an important section, the Q&A section. So for the next part of this, we have collected some general questions that we would like for our panelists to answer. So are you guys ready? Yep. Okay. So the first question, maybe Anushka can take this. So can you please explain to us the use of mitigating circumstances? Do you know anybody who has used mitigating circumstances? How does the whole thing work?
Okay, great. So just a bit of overview of what mitigating circumstances means. And I think I want to stress on this even more because coming from a South Asian background, I don't really think we're very encouraged to, sometimes take time off. I think sometimes we're very pressured into being the best because maybe it's just a personal experience for me. Like it's not necessary that it happens to other people, but I think it's a South Asian trend and I would like to voice it. It's okay sometimes that life gets in the way because you're away from home and you're dealing with a lot. Sometimes it can get a bit overwhelming, and the university really understands that. So a couple of instances that do qualify for mitigating circumstances could be the death of a loved one, or because last year we had online exams. That's why some places they don't have enough internet connection, as some of our friends faced last year. So because of that, they weren't able to submit on time. That's a mitigating circumstance. Sometimes mental health issues that come up during your examinations. Warwick Law School and Warwick as a university really understands that, and we have specific well-being tutors for every year. So if you do find yourself in a really tricky situation and you think that it's affecting your ability to perform in your examinations, I would urge you to talk to your well-being tutor at Warwick Law School because they're really nice. Maybe you don't even apply for mitigating circumstances. Mitigating circumstances, what they do is, I'll explain in a minute, but I would personally request you to go and talk to someone because it just makes you feel better that someone on the other side, someone who you're submitting your examinations to, understands that life has gotten in the way. So mitigating circumstances, basically, I've used them personally because in first year, not during my second year when we had online exams, I exercised them in my first year. And it's basically what it does is either it allows you to submit it a bit later, you get an extension, or you get like a 5% leeway for probably submitting it a bit later, or they kind of understand and they work through the issue that you have. So I think in this scenario, what it would be is that maybe you lost your internet connection, or you were going through something at home which impacted your ability to perform. So it would include you kind of supporting that with some kind of evidence. So I think the steps for mitigating would be, first, talk to your personal tutor, talk to your well-being tutor at Warwick Law School. Each year has their own well-being tutor. Talk to them. They'll probably guide you through to the website where you will have to submit evidence. I think it's a bit harsh, like when you've faced the death of a loved one, or you've had some injury or some personal circumstances. But it is also important for the university to know that you're not putting up a farce, or you're just not taking them for a ride. So it's important for you to support that with evidence. So I know last year, when someone's internet connection broke down during an examination, they kind of submitted a newspaper article that said that, okay, in this area, there was no electricity for this period of time to this period of time. So that can be counted as evidence for poor internet connection. Or I think the university will really help you depending on your circumstance. They're really, really nice that way. And the last thing that I would like to caution you guys about is that mitigating circumstances, yes, you can apply for them when you're going through your exams or when you're going through a submission, but they will be reviewed at the end of the examination cycle by the examination board, and only then will they be passed. So only when you get your results at the end in July, that's when you know whether your mitigation has actually been accepted or not, because there is a certain threshold that they use it to. Obviously, with the coronavirus pandemic, I think the Warwick Law School and the university itself understands that we all have been put in really trying circumstances. So I think they're really helpful, but this is the procedure. And if you have any more questions, then please don't hesitate to ask me.
So much for that. The next question is there any schedule making or time management tips you would like to give people? How do people cope with modules that have very close deadlines or exams which are like a day apart? Anushka, if you'd like to take this.
Yeah, I'll take that. So a couple of tips that I'd give for this, and I can just talk from my experiences. I'm not the best at time management, I will admit. Like, I'm not perfect, and I'm still struggling with my deadlines because I have 2 essay submissions due at the end of this month, and God knows how I'm going to finish it. But what I would say is work backwards. There is no perfect formula as such to be, perfect, nor am I, nor is Vartik. But yeah, if you have 2 submissions that are really close to each other, my suggestion would be to schedule enough time for them beforehand and work backwards. So the submission that you have later, finish it first, and then work on the one that's closer, right? And the one tip that I would strongly give you guys is that not to start doing both of them simultaneously, because each module demands something different, and you don't want to get mixed up in the preparation. Like, so I'll give you an example from what's happening with me right now. I have a Brexit submission due and a competition law submission due. So I'm almost done with my Brexit. That's why I can focus on competition, because I don't want a very European mindset to kind of be cast on my competition law essay, because you don't realize it, but it happens. So that is one tip that I would like to give you guys. And another tip that I have is to set realistic goals. If you think that you can finish 10 journal articles in a day, good for you, but I don't think I can do that. Like, be honest with yourself and set a realistic timeline for when you think you can get your research done, and when is the best time for you to, get your drafting skills out. Like, sometimes you just don't feel like writing. It's okay. It's fine. Don't put pressure on yourself. It's completely all right, but just be honest and realistic with yourself. That would be my advice to you guys.
Thank you so much. Okay, now we're going to move on to a few course-specific questions. So the first one is, what are safety nets and how is it going to help me? Vartik?
Yep.
If you'd like to take that one.
The way the safety net essentially operates is that it is a calculation based on either your previous year, which for first years it won't be the case, or your assignments up until the exam itself. So they will collate an average out of your results that you have at Warwick, and that will be the minimum threshold that they will hold you to. So, for instance, say the university calculates my safety net to be 63, and say in my exams I score a 67, they will give me the 67 mark rather than the 63 mark. But if, for instance, I score a 63, but sorry, my safety net is a 63, but I score a 55 or a 60, they will give me the higher one, which is the safety net. So essentially, the safety net acts as a safety net, as it says, is that it doesn't allow your mark to go any lower to what they essentially say. It can't go lower than, it can only go higher than that. So that is what a safety net is generally. How it works in terms of Warwick Law School is that, well, Warwick Law School simply doesn't have a safety net. Well, we were given, it was quite a shock for us last year, to be honest. I think we were quite disappointed when we realized that, and quite scared that we don't get a safety net. But I think now in retrospect, we can say that I think that motivated us to work harder and make sure we do well. But the way that it works is that we don't have one at Warwick Law School. And essentially, what that means is that we can, whatever our average of our exams is, we just get that. And the reason behind this, I think, which we were given last year, is that the LLB course, the 3-year course, is regulated externally by the SRA, which is the Solicitors Regulatory Authority. So it's not like the final body that regulates the course is not Warwick itself, it's actually the SRA. And since it is a professional course, it is a qualifying course, which essentially gives you the basis of practicing law. The SRA mandates that there should be no safety net for it, and essentially we're left to fight our own battle, I guess, prepare us for the real courtrooms when that eventually comes around. But yeah, that is the reality of the situation.
Thank you for that. The next question: what books or resources did you find most important for each module? Maybe you can keep it specific to the first year modules, or maybe a few second year modules.
Vartik, do you want to take that one?
Yeah, sure. I just have a couple. I would say one would be the reading lists on Moodle itself. So especially for your essay type questions, the lectures usually link you dozens, if not more, articles which are relevant to your research, or which you could pick up points from and use in your essays and in your exams, essay type questions. So that is a great starting point, I would say. Of course, if you want to take your research further than that, that's perfectly all right, and it's probably recommended. But your reading list for essay type questions, I said, would be your key resource. With regards to, I would say the next one would be more towards the problem type questions, which would be the Law Express revision guides. Those give you a snapshot, essentially an overview of all the important points, all the important cases, all the important statutes that are relevant to that specific area of law. And they're really quite digestible and intuitive in that way. It's easy to understand, and it has quite a few diagrams, mind maps and all, which can really stick in your head. And of course, in this case, you can even refer to them as and when required during your exams. Anushka.
Yeah, thanks for that.
Thank you.
I think those are spectacular resources that you can use. And sometimes, like for essay type questions, even a generic like Google search would give you certain like articles that are quite relevant. So I would say that if you really want to go the extra mile and get a first, then I mean, Google is like your playfield. You can do whatever you want. But another resource that adding on to what Vartik said, especially for first years, I think would be in tort and in property. I think the prescribed textbook that we had at that time, it had like problem questions at the back of each chapter. I think that was really, really helpful for me, at least in first year, especially with property, because it was one of my favorite modules, and the textbook was really helpful, even though it's not digestible at all. And in your first year, you may feel like, oh my God, why do I have to read all of this? But, if you work your way through and actually understand and kind of navigate your way through, take some time out to figure out what's going on, it'll be really helpful if you can engage with the questions given in the textbook itself.
Thank you so much. Would you recommend watching all the important lectures once more? Is that something you think? Yeah, can you We have only under 10 minutes left, so if you guys can keep your answers brief, then I would appreciate that.
Sure. I think if you don't understand a certain concept, then revisit it in the lecture. But given the way that law works is that you already engage with certain concepts in your seminar, so they happen to stick. So I think if you really, really don't understand anything, then go back to the lecture. Otherwise, just kind of, get the law down in your notes, figure out the issues that are underlying, get your cases right, and get the nuances of law, and just keep moving forward rather than going back to the lecture. That would be my advice.
I would say that if you sit down to start watching important lectures, then you'll end up watching all of the lectures because they're all important, more or less. And the lectures themselves say that it's just a starting point, and they expect us to, build on what they say in the lectures. So I would say if there's anything you don't understand foundationally, then definitely do revisit those parts of the lectures. But I would say that if you were to watch your lectures again, you'd be wasting your time because the textbook and other resources are much more in much more depth, which is what you require to do good in law.
Thank you so much for answering all our questions in the Q&A session. So now
Hello, I have a question. Yeah, so I have a more specific question regarding the electives taken by you guys in the second year. So if I'm correct, you guys took the intellectual property law lecture in your second year, and then Anushka took the competition law module in the third year. So my first question is regarding these two modules because I'm interested in them and taking them in second year.
Okay.
So will it be difficult for a first year to take these electives in second year, or is it okay to take them? What are your thoughts? And second question, which I have, is basically directed on how an individual should approach taking electives in their second year. Should it be more of broadening your horizon and taking as many different electives and trying to figure out what you should do? Or it should be more focused on, let's say, if you are taking competition law, you take intellectual property law with it, or you take some other business module and you streamline it, or you take only criminal modules and you streamline it.
Okay.
Thank you.
Thank you for your question. That's really great. I think I'll answer your second question first and then go on to the first one. So the second question is, honestly, my advice would be talk to as many people as you can that have taken different kinds of modules, and honestly read the questions. I think there are even presentations by the lecturers. Like there is a module open day, if I'm not wrong. So do attend that. I would strongly recommend doing that and kind of understand what you're drawn towards. So I automatically was drawn towards intellectual property, competition, and stuff like that. And in my second year, I had taken data protection because I was super interested in it. But because I couldn't get it, in a way, it worked out well for me because I ended up taking a finance module. But what I would say is that don't stick to something. Don't think that you have to go a certain way, or don't think just because you're taking IP, you have intellectual property, just because you're taking intellectual property, you have to take this, or just because you've taken criminology, you have to take like international theory of criminology or whatever. It's not important. I've had friends who've taken race modules and commercial law modules. So it's all about understanding what you're interested in and what you think. Also look at it strategically, I would say. If you're good with essays, take an essay-based module. If you're good with exams, take an exam-based module. So kind of work out your way, be smart about it. And answering your first question, I don't think that competition and IP for a second year would be tough at all. In fact, I was late in taking competition in my third year. I wish I'd taken it in my second year. But yeah, it's a great module. And honestly, I think Vartik will agree with me on this. Sometimes we took IP only for the lecturer, more than for the topic itself. We took it because we fell in love with the lecturers. So sometimes that's okay too, because the lecturer literally sparks your interest. So it's completely up to you.
Okay, we have another question in the chat box. So Maya asks, what specific advice do you guys have on revising the first year law modules and where to start with studying?
Well, I would say that your starting point in any case should be your lecture notes, which are given by the lecturer. I think the lecturers, even in your first year, understand that this is your first time sitting for law exams, and they're more receptive to that. They give you a bit more detail probably than we get in our second and third years, where we're left a bit more to figuring things out for ourselves. So that is quite an advantage, I would say, for you being in first year. And that should be your starting point. And in terms of revising, I would say as you go through your materials, and Anushka alluded to this earlier, she uses Quizlet, for instance. I personally used to create mind maps as to what different topics in a particular, for example, tort law. I used to create mind maps as to what the different topics were, where the different links were probably between the different topics. And that really gave me not just a detailed understanding of specific areas of the module, but sort of an overview, the bigger picture essentially. So I would say that is a great revision tool, whether it's the way you do it, the way Anushka does it, or the way I do it, or you find your own way. It's definitely a great tool, both of these two. Or if you have anything else in mind that you'd like to try out, maybe from your school days or something like that. It's not the first time like we're studying, but yeah, no, definitely some of those tools could be applied here as well. And in terms of other advice, I would say if you're really struggling with something, just drop the module conveners or the lecturers an email. They're all very nice people, especially the module conveners of first year. I think Anushka will agree that property law and tort law, both of the module conveners for those are quite admirable people and quite helpful people, as is the case with the others as well. So yeah, definitely there's a lot of support available even from your seniors. If you know any second or third years, they'll be able to guide you if you're particularly struggling with something. But yeah, there's a lot of support. It's just about you going up and using it, I would say.
Yeah, I think just another thing that I would like to add.
Thank you so much.
Is that find out, like it's not really that hard, like for each topic that you're interested in. Like I think for property, I can say I studied term 2. I didn't even study term 1 because I didn't understand the theory of it. I just studied Jane's, I'm assuming you have Jane. So I just studied Jane Bryan's term 2, everything, and I got a first and it was great. So kind of be strategic about it. Figure out, it's not that hard to figure out the issues that they want you to see. Pick up those issues and make sure you have arguments for and against it, and always propose reform. Like that is one way that's always going to get you a first, is that discuss both sides of the argument, say which one you think is stronger, and then propose a reform. So that's my advice to you.
Thank you so much for that. Is there any other questions before we move on?
Yeah, I had a particular question. What would you suggest, like a particular structure for us to answer any problem-based question? Should we use a particular structure or actually go on with any kind of form?
Thanks for your question, Arushi. So I think what we were told in pretty much every module of ours was to use a structure. Anushka, I think it was IRAC, if I'm not wrong, which was, I think Anushka will give you the full form of them.
Yeah, it's basically, so IRAC, I don't know if you've interacted or if you've been taught this in seminars before, but I hope you have been, because if no, then that's just great. But anyway, so it's basically issue. I think R is for the rule, A is for application, and C is for conclusion. So it's pretty self-explanatory. If you stick to this structure, at least in your first year, I didn't, because I was still trying to get on to grips with it. But more or less, if you talk about what issue you're addressing, what statute or case you're applying, how you're applying it, and then concluding whether it's guilty or not guilty, or whether it goes one way or the other, I think you'd be good. That would be the structure that I would suggest.
Thank you so much for that. We will take one last question. Anybody with a question?
Yeah, I had a question, but I have two. So first question is with regard to, so in an essay-based question, while we are answering it, a lot of the seminar tutors have told us not to be too descriptive. And a lot of seminars have told us that a little bit of description is okay. So what are your thoughts in answering an essay type question? Should we be a little bit descriptive and then form an argument which is covering both sides, against and for, or should we make an argument which is our argument and try to justify that? And my second question is that can we, if you guys are comfortable with it, and if you have saved certain of your answers of your modules for your first year, can you please share it with us so that we can use it for our advantage? Thank you.
I'll take the first question. So for us, I think when we were doing our essay questions on our first year, of course, we didn't have any word restriction. We just had a time limit. And I think many of us struggled with that. We just went on and on in detail, writing about, whatever we could really fit down in that period of time. And then towards the end, we struggled with the conclusion. I think you mentioned something about whether we should address both sides of the argument or just address yours and then focus on that. You definitely have to address both sides of the argument, regardless of what your position is. The main body of the essay type question has to be, I would say, equally or more or less equally, addressing both sides of the argument. It's really your conclusion where you actually address which side of the argument you prefer. So that should be that part. But the advantage that we have right now is that we are given a word limit. So I'm not sure if you're aware or not, but there are word limits for the law exams this year as we had last year. So I think for 2-hour exams, it's 2,500 words. And for 3-hour exams, it's 3,750 words, which essentially equates to 1,250 words per question, regardless of whether it's a problem question or an essay question. Of course, if you use fewer words in your problem question, those carry over to your essay question. So you could really make it up to 2,000 words. So I think rather than us guiding you on how detailed it should be, it's more about how much you can fit in that word limit, because I think you will inevitably tend to overrun that word limit. So if you can, it's quite a fine balance, I would say. It takes a bit of getting used to, which is probably some exposure you've had to that in your essay-based modules itself, where we're given a 3,000 word limit, for example, and we have to stick to that. But it's more about keeping it within the word limit and sort of cutting down the level of detail in case you exceed it. But I don't think you'd ever be in a situation where you've not exceeded the word limit. At least I haven't been. I don't know if Anushka has been. We always exceed the word limit, and then we tend to cut down the unnecessary points.
Yeah, I think
thank you so much for that response.
I'd just say that.
Yeah, continue.
Sorry, I'd just say that be as analytical as you can. Description is only for laying down the law or explaining a rule, and don't spend too much time on it because they're actually interested in seeing how you can analyze and apply the law. So keep your descriptions to a minimum and your analysis to the maximum. That's what I'd say.
That's great advice. So thank you all for attending this session. A special thank you to our panelists, Vartik Mehta and Anushka Manglani, for taking out the time to speak with us today.